night to the listeners and viewers. Welcome to you guys. Thank you to all those who have tuned in to this program tonight. Tonight we have two eminent attorneys, Shirlan Zita Barnwell, the president of the St. Vincent and the Grenadines Bar Association, and Francis K. Paul, the president of the Grenada Bar Association. Ms. Barnwell is a practicing attorney of over 10 years. Before coming to law, she obtained a Bachelor of Arts degree in Psychology and Literature from York University, Canada, with honors. She's a Chevening Scholar with a Master of Arts degree in Development Studies from Leeds University in the UK. She received her training in law in England. She also holds a Professional Development Certificate in Parliamentary Governance from Barclay University in Canada. Ms. Barnwell served as a senator for the opposition in the Parliament of St. Vincent and Grenadines for the period 2015 to 2019. During her time in Parliament, she shadowed the Minister of National Mobilization, Social Development, Gender, Youth, Family, and Persons with Disabilities, as well as the Ministry of Justice. Mr. Francis Paul is an attorney-at-law with over 20 years' experience. He received his training in law in the Caribbean at Cayman campus in Barbados and Heward Law School in Trinidad. He's also the holder of a Master of Laws degree from Kingston University in the UK Dispute Resolution. He has wide experience in various areas of the law and has served as a magistrate on several occasions as a court-connected mediator. The program tonight is sponsored partly by GEM Professional Solutions, by GEM FM, broadcasted out of Canada, and by TAO. I want to especially thank TAO for the assistance in this regard.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Thank you, Tom. So, lawyers are often maligned, criticized, condemned. You listen to the radio, they always subjects of cussing off. But at the same time, whenever we have an issue or difficulty, we rush by a lot. And I think we can safely say that the society cannot function without lawyers. These two eminent persons here tonight, these two eminent attorneys, are here to tell us the good works that lawyers do, the issues that they address, the challenges that they face, and in particular what they seek to do in terms of legal education so as to help develop the society. So we are going to hear that lawyers are not just about money, but lawyers are about trying to develop the society. And I think the wide preparation, the wide education, the wide areas of knowledge of the two eminent attorneys here tonight, which I referred to in the introduction with us. Tomorrow starts a week of celebration, a week of education, a week of activity by the Brides and Vincent under the caption Law Week. It's fitting that Mr. Paul is also here because Law Week will be taking place in St. Vincent tomorrow, but my understanding that it is something that commences every day. So, ladies first, my name is Barbara.
Thank you very much, Mr. Lane. Hi, Francis, and thank you so much for having me. Yes, starting
Hi, Zita.
tomorrow, September 23rd to Friday, September 27th, St. Vincent and Grenadines Bar Association will begin its Law Week. Our theme is legal pathways to peace and justice. And one of the goals, or the main goal actually, is to engage with the community as well. And that community includes, call it if you want to say, in the village. We have been able to secure such one engagement, but the majority of our engagements will be secondary schools and one community college, which will be on the Friday. So part of the engagement has to do with educating, as you've said, about legal education. And primarily, we'd like to speak to students on the most basic level to help them understand how the justice system or legal system works. Explain to them what happens in court, explain to them the tier system, starting with magistrate courts or tribunals, then magistrate courts, the High Court, the Court of Appeal, and finally the Privy Council. And also, we have formed some partnerships. What might seem very obvious, but isn't, is the relationship that we have with the Office of the National Prosecution Service, which is the Crown or the prosecutors. And they too are on board and will be able to make some of the trips to talk to students about what prosecutors do, talk to them about as well, part of assisting the police in a way to say, in terms of investigation, in terms of justice, to say, if I see something as a witness and I'm afraid, to understand that the Office of the National Prosecution Service provides what is called witness care. So it's before, during, and after witness care program. So we have tomorrow night, we're actually going to be on Voices, Jomo Thomas's program, and one prosecutor is going to be there along with me and someone from the police, an officer, who will be speaking about criminal investigation. I mean, it seems like a lot in a short space of time, but it's the beginning for our law week. We were trying to have a mock mediation session, but once we weren't able to have everything organized to have that in the week. And on Friday, our last day, as I've said, we will be at the community college, which will have maybe, hopefully, we'll have about 100 students because the college has organized a time where we would have as many persons as possible from their body, students and teachers. And with that, we're going to have how laws are made. Hopefully, we should be able to have the Speaker of the House, Ms. Rochelle Ford. She's just trying to iron out certain things. So she will speak about how laws are made in Parliament. We will have someone from the magistracy, Magistrate Tamika De Silva Mackenzie, who was recently appointed earlier this year to speak about to the students how the court system works in applying the law, and someone from the Bar Association, or maybe several, maybe two, maybe at least two, one prosecutor, one defense, will try to tie things in about here is how laws are made, here how laws are applied from the level of the bench, and these are prosecutor or even a defense, and there you have if it's a claimant, or in the case of criminal matters, the defense and prosecution, and then in the case of civil matters, a claimant and a defendant. And should be able to do all of that conversation and continue it even after Law Week. There have been some conversations already with the Ministry of Education to streamline this with other entities who are doing similar things, to see if we can have a real solid programs to do throughout the with all of the schools, whether it's primary school, tailored, secondary schools, and the tertiary level schools. And that's in a nutshell for our Law Week.
And Francis, we have the same name, really, right?
Afternoon. Well, good evening. Good evening, Mr. Layne. Good evening, Zita, and to
Hi.
all the viewers and listeners. Well, I'm so happy that St. Vincent hosting Law Week. Is it the first time? Is it the
No,
first?
it's not. It's not
Oh.
the first time, but it's the first time in a very long time.
Right. I'm happy to hear so. And I know Rogers Ferguson Casey would be very happy to hear so as well.
Indeed.
Since
Indeed.
Law Week was his brainchild, which started in Grenada many years ago.
Mhm.
So we celebrate Law Week every year. I don't think that we have missed a Law Week, maybe save and except during COVID. So this year we have a nice rollout plan as always. We have a theme. I don't want to let it out of the bag yet because we're still refining it somewhat. But we always start off with a church service, and we go around the different parishes. We were in St. Patrick's year before. Last year we were in Corinth in St. David's, and this year we want to hold the church service in the Grenadines. So we start with the church service on the 27th of October. Hopefully that's when it commences. That would be followed by luncheon among the bar members. And then Monday, we have what we call the media day, whereby we will go on Good Morning Grenada, sensitize the public about Law Week and what to expect. Evening, hopefully, we get a slot on Beyond the Headlines, where we plan to have a panel of lawyers and someone from the medical field to discuss, personal injury claims and how to what to expect from an expert report. Tuesday now we have what we call the police station and prison visits. So whereby we visit the police stations, would examine the cell, would make recommendations. If there is need for maybe lighting, a mattress, we would recommend or find someone who can contribute if the bar cannot do it itself. Then the prison visits, basically the same thing. We go to the prison, examine the cells, look and see what the prisoners need, and we intend to collaborate, engage other members of the bar, not only the executive, but the general membership, particularly those who practice in the criminal division, to assist. Because I can tell you, when those guys, the magistrates always complain, when prisoners come, or inmates, you should say, of those folks on remand come to court, they will tell you, Your Honor, I don't have clothes, I don't have pants, I don't have shirt. And they do not have. So that is something we are looking at. And in terms of mattresses and also toiletries, just simple basic toiletries like, toothpaste, toothbrushes, soap. Wednesday, we're looking at the school visits now. And our school visits, we want to engage the schools in the different parishes. So at least one school in every parish, at least. So we look for volunteers from among the general bar. And as Zita said, we go into the schools and sensitize the students, tell them about the law, what to expect. I have done this several times, and the questions they always ask is dealing with criminal offenses.
Expected.
Yes. So Thursday now we have the mooting competition, which is annual as well, and we engage the students from TAMCC. You have a fact pattern which is given to them. So you have claimant, you have defendant, you have an actual case. So it's a real live case. Come before, most times we use the number one magistrate court. We have a sitting judge who would preside over the proceedings. And at the end of the day, both parties present the case and the decision or judgment is handed down by the judge.
Okay.
Friday is party time. Friday is the social. And Saturday, and that is another fixture during Law Week, what we call the pro bono day. We usually have it during the week. And Saturday is usually the day when you unwind. But what we decided is that, folks are working during the week, and to give everyone an opportunity to take advantage of the pro bono day, we are hosting it on Saturday this year, hopefully at the GBSS auditorium from 9 to 2. So this is just engaging the public and giving back. So it's all legal education, interacting with the public and giving back. Because Law Week is not about really the laws, it's about giving back to the public and sensitizing the public that, this is what we do. We serve, we assist, we sensitize folks about the law. And, to dispel, as Mr. Layne, as you said, folks always have, lawyers, all they do is just take people money. I'm just
Yeah.
Yeah.
So during long week, we don't take. We give.
Yeah, okay. The
Yeah.
pro bono day involves what?
But it involves free legal advice.
Okay. So
Right.
people who really, yeah, sorry.
So
No,
what would
I was
happen
going
is
to
that
add. No, sorry, Francis. I was actually going to add ours is on the Friday. The last day of our law week, the pro bono is on Friday. But that's a good idea to do it this Saturday. I just maybe sometime you may think that I will go with this week, this time around on the Friday. But
yeah,
certainly we'll try and see if how you should tell me how it works for you now. You're doing it for the first time.
the
So we can
first time
do that the next year and actually try this
I
Saturday. I
would
mean, since Vincent came
I
to
would
a different
definitely give you a
environment.
feedback.
Yeah.
Yeah.
So
Because we
somebody
also
was
find that we
Atlanta.
get a bigger turnout because folks have more time. And when we have pro bono day, there are several persons would say, I wasn't aware or I didn't have time. I've gotten time off from work.
Okay.
Right.
But most people do
So,
not work on Saturdays.
yes. So you'll be heavily advertising that because I know there are people all over Grenada who have what may appear to be, well, to them different land issues, mostly, as you know in Grenada. It's mostly about land. So they
Definitely.
want to, yeah.
Definitely. We'd have some media presence as well as flyers out, informing the public of the pro bono day.
Yes. Yes, so that's quite a bit. So that's
Yeah.
what you do.
In 1 week.
Yeah, for 1 week.
That sounds I'm really very impressive. I would tell you that much. It really involves a lot. And I must congratulate you guys, even though you have not yet
A
executed it.
lot of planning.
Yeah, the planning.
Meetings every
Yeah,
week.
yeah.
And in a sense, that's you are just in a sense elevating and compressing in 1 week, concentrated from what I guess you do throughout the year. Because, for example, I know the Grenada Bar Association, you have the peace initiative on. How that has been going?
Right. So we started the peace initiative. That was in May when you had that spate of gun violence. We started the peace initiative and it lifted off quite well. We garnered a lot of support. I would say after Carnival, there have been a brief hiatus after Carnival, but we intend to start again, commence meetings from tomorrow. Used to have meetings every Monday. We intend to get back on track because, as you saw, that was Friday, not Friday last, the Friday before that, there was another homicide, gun-related homicide in the south of the island.
Yeah.
So while we may have taken a brief hiatus, gun violence and violence in general continues. So the work of the peace initiative was generally to stop the gun violence then. And the ultimate goal, the long-term goal, is to reduce violence in Grenada as much as possible. We know it would not be zero, but that is our aim. So we intend to go into the communities, go into the schools. So that's why going to the school for Pro Bono Day would also fall in line with the objective of the peace initiative. Because just before Carnival, our plan was to engage the schools before school reopen, so that when school reopen, we would come in to speak to the student. It may be a bit late, but that is still on the calendar for the peace initiative, to go into the schools and engage the students, because it starts there. And all you have to do is come to the court on the juvenile day, and you would see the mass of students. I mean, it's really, and how should I put it? And it's unsightly, so to speak. Come one day and see students from several different schools with their parents just line up from the steps, come right up to the court. So we want to eliminate all that by going in and talking to the students and get to the root of the problem. So we would have engaged the business community, mediation, trade union, council, as well as other stakeholders, including religious leaders, to assist us, because as the bar, we do not have all the answers. We do not have the expertise in certain areas. And that's where Claude Douglas as a sociologist and also Dr. Nice Chaitan, a crime reduction specialist, also on the team, part of the peace initiative to assist us in achieving that goal of crime reduction in Grenada.
Zita, your team is what for this year?
If my sorry, I didn't hear the correct. My team is what?
The theme for the law week.
Or the theme is legal pathways to peace and justice. But
Right.
but I am very intrigued by Grenada's peace initiative. It's called Peace Project.
Yes, indeed, yes.
Yes, peace
Yeah.
initiative.
And I heard him say something about Juvenile Day. Is that a court day in Grenada?
Yes, once a month there is a juvenile day, that day that just designated to deal with all the juvenile matters.
Oh wow, we don't have that here. Who initiated that there?
Well, it
It's
had to be
always
the
been.
courts. Yeah, and that happened years ago when the Juvenile Justice Act came into effect.
Okay. It's
So
not
maybe around
in effect
2012,
here.
2013, thereabouts.
Yeah, that's good. It's not in effect here just yet.
Yeah. Because I asked about the peace because I know, well, homicides in Grenada is at a level that over the last 2 years, elevated level for us. But in St. Vincent, you had how many homicides last year?
Yeah, we do have an issue here. And as Francis mentioned, it's a lot of it too is crime related. And just last week, Friday, in the heart of Kingstown, there was a shooting 1 block over from my office. And I wasn't even aware of it until someone WhatsApped and asked, you guys better be safe in town, don't really go outside because there was a shooting. The young man was killed. So it is an elevated situation in St. Vincent, in particular, dealing with gun violence. It's no longer, you have those in between, yes, of people using their cutlasses. And one of the things that, or one of the features of these young people, from my experience, that you see in the court when someone is arrested and charged for any kind of violent crime, they're young people under the age of, say, between the age of 21 and under 35. And if they were assessed, there is some form of, whether it is mild to moderate, of some kind of mental health issue. Sometimes it's bipolar or depression or whatever it is that is found. This doesn't mean that necessarily they may not be fit to plead, but it is really interesting basically to figure out and to see, as Francis said, you have sociologists and psychologists on their team, which is pretty good. Because one of the things you can't escape is that these people come from the belly of some society where it is that along the road, conflict resolution was not something that they understood. And with all of the other things that you have here, the distractions that people tune into, the social media, the rap music, some of the same dancehall music that speaks to violence, that intrigues them to the extent of thinking that I can settle my dispute with a gun. And we have to somehow, as Francis said too, it's not something going to come to a zero. We may not be able to bring it down and say, oh, we only have 10%, but there must be some efforts working together with the police, with any other stakeholders in the system here, whether it's legal and justice system, and the community at large, to try to reduce gun violence in St. Vincent and Grenadines. I know the police last year started an amnesty program. I really cannot say how successful that has been. Unfortunately, the bar wasn't involved in that, but I did have some unofficial communication that they would have liked to include the Bar Association, even if it meant that the lawyers can encourage people. If you don't want to carry the gun yourself, then you can take it to a trusted attorney who will bring it in if you don't want to be identified. that kind of stuff, I don't know how many guns they were able to get.
Okay, Francis?
Well, we had an amnesty as well. The government had an amnesty that I think expired on the 30th of July. And after the amnesty, and it's the same way that there was you could have given someone, particularly your attorney at law, to bring in, because there was that level of secrecy, or you can, being anonymous then, so to speak. But the thing is, as soon as the amnesty expired, then came in the amendment to the law, to the Firearms Act, which increased the penalty significantly. Where it was a minimum of 2 years, 5 years maximum, it became 10 years, 20 years maximum in the magistrate court, and in the high court, 20 and 40. And not only that, there was an amendment to the criminal procedure code as well that took away the discretion of the magistrate to grant bail in firearm-related charges. So as long as you charge with possession of a firearm, no bail in the magistrate court. You have to apply to the high court for bail. The magistrate does not have that discretion to grant bail.
And that discussion is still going on in Grenada, I understand.
Well, it's still going on, but the law is there.
Yeah, but
The amendment has taken effect.
Yeah, but in terms of putting a framework in place to expedite the consideration of bail by the judges or the magistrate. I think that the judge can direct the magistrate.
The judge can direct the magistrate. I don't know how practical it is if it would be done. Usually the application is before the high court, because since the magistrate does not have jurisdiction to grant bail, automatically you have to make an application to the high court. And then is the availability of the judge to hear the application. So that's where the delay may set in.
Right, because in the case of St. Vincent the Grenadines, the practice has been, in terms of the High Court hearing bail application, it has been on a Friday. So if we think about it, if someone gets arrested a Sunday and a Monday, then that application is set down really a bail application, unless you're going to have a certificate of urgency as to why for this particular person. I mean, I guess for everyone, I mean, every single matter, you could say, well, it's urgent because somebody's liberty is at stake, and therefore a bail application should not wait until a Friday to be heard. But the situation of those bail applications would have been, one may have been refused from the magistrate court and now being heard, put down for hearing at the High Court. So in any case, whether it's in that situation or it is someone who's now newly arrested, all of these things should not be waiting for an entire week, especially if the person is going to be granted bail eventually anyway. Why should you be sitting and waiting in these spaces that are not of the best spaces before you're going to have a bail application?
But you see what happens, because you come before the magistrate if it's a summary matter, and just as murder, automatically the magistrate doesn't have a choice but to remand you to prison.
Yeah, you're serving time.
Your attorney now have to go and make the application to the High Court, file that application, and wait for a hearing. No, it has there are consequences for the person. You have that presumption of innocence. So you presume innocent. Even when you come before the magistrate, you're presumed innocent. But the point is, you may be gainfully employed. The week or two you're on remand, you may lose your job. You cannot provide for your family. So there are consequences for someone, and that presumption of innocence.
That's exactly what I was just thinking, the presumption of innocence. You think about it, you actually start serving time before a matter is heard. And one of the things here that is quite, it's not a very good thing sometimes, where it is that you may be locked up on a Friday, may not be just for gun possession, and you are locked up, or you're arrested and charged at a particular time, wherein the magistrate has already closed. You ain't not giving any police bail, and you know for sure you're serving two days and some in prison, in jail by Monday to hear. Ordinarily, before you hear, you get you're arraigned and have a hearing as to whether or not you're having bail. So think about this now, where it is you're arrested. If it's on a Friday, there go 2 days as normal, and then you have to wait for the application to be heard in the High Court, and hopefully it will be an automatic transfer over that period, So within that same day, the Monday or the Tuesday, your matter is heard. So within a day, the practice ought to be, if we are going to respect people's right to liberty and your presumption of innocence, that within a day, this bail application must be heard, if not the same day.
Well, that's how it should be. But I can tell you that's not what actually persists. That's not how it is. That's how it should be.
So let me ask. I guess at the end of the day, you have to balance some things, but I think the position of if I understand it, of the buying Grenada is that the risk is not of such gravity, like when somebody charged for murder, that you should remove the power from the magistrate. If I understand it properly.
Well, that's so I can't speak for the entire bar, but I can say for the criminal bar, that is how we see it. Because what we're saying is that the magistrate has that discretion now at the end of the trial, or either as a guilty plea, to sentence minimum 10 years, maximum 20. But the magistrate does not have the discretion to grant bail.
Yeah. Let me ask this though. Do we have a system of having a judge on duty? I know in Trinidad they have something as that, where
I am
a roster.
I am not aware of that.
If an urgent matter comes up, there's always a judge who's available for it.
I am not aware of putting it as a judge on duty. I know if you have an urgent matter and you file a certificate of urgency, the registrar would try the utmost to get it before a judge. But to say that you have a judge on duty, that I can't respond to that. I'm not sure.
Yeah, but I think they have that system in Trinidad, where there's always a judge who is there available for any urgent matters, any urgent application or anything like that to treat you. So I'm seeing somebody who knows Zita Thomas to say that once you are denied liberty for 48 hours and then released. I think he's speaking about that period when the police can detain you for questioning.
Without an arrest.
Yeah.
For 48 hours.
Okay.
That's the maximum time done. I think what it is being abused. It's really abused. They
So,
keep it to the
and I can
48.
give you a perfect example. Imagine that you are detained on Wednesday evening at 5 o'clock, right? 48 hours fall Friday at 5 o'clock, and you get charged. So that means you've been in custody Wednesday, Thursday, Friday,
Saturday,
right? You have to come before the magistrate. You still have to stay Saturday and Sunday, and it happens.
I think let me add. I had a situation recently where, when I say recent, I actually went to the Court of Appeal, and the reason for going to the court was not on this particular point, but it's something similar to what Francis said there. What is even worse is that it's a very summary matter, the theft of a small amount of money, less than 300 Eastern Caribbean dollars, locked up on a Friday, charged on a Friday, and then not, and for something that certainly could have probably been given police bail, not given police bail at all, because it was 200 and something Eastern Caribbean dollars, and held until the Monday where he pleaded guilty, yes. But I'm not sure that at the police station he says, well, I'm gonna go plead guilty, and therefore just keep me until Monday. He just keep me until Monday. Or if there's some indication that, because one of the things people allege that for some matters, police encourage them and tell them, but you might as well plead guilty. And if you plead guilty, this is what's going to happen. And so police interfere rather than leave the persons go to especially if they don't have a lawyer with them, to try to encourage them as if, well, at least let me get this one out of the way. People need to go plead guilty, be honest. people are innocent until proven guilty, or if they're saying to themselves, well, I know I have committed this offense and I want to plead guilty. But that thing about getting police bail is something that as well we need to educate the public on, so they can ask if it's not offered. Is it possible for me to get this, and why is it I cannot get it? That they would police will be able to say, well, listen, for certain matters we know you can get it, release on your own recognizance, and certain matters when they're serious you can't.
Well, Zita, I don't know how, when you say police bail, how it works in St. Vincent, but how it works in Grenada, when it doesn't matter irrespective of the offense, right? The police has to call the magistrate and explain, oh, well, I have Francis Paul here.
Right.
He's charged with disorderly behavior or obscene language, right? I'm applying for bail for him. And the magistrate now would set the bail. No, it depends. The officer might say, well, he XYZ, he has a lot of prior convictions. So the magistrate may say, okay, well, I bring him before the court Monday or Friday. I'm just saying. So how it works is that the officer in CID or the arresting officer has to call the magistrate to apply for bail.
But I'll tell you what my experience has been, though. And you haven't said I was really check our legislation out, because from my experience of being there, it has been the chief of police who had made that determination. I've also had the experience where I had to engage a magistrate to have a bail. But I have been in a situation where it is that someone was arrested. But mind you, though, as you say, it doesn't matter what offense. The offense in which the experience I've had where the chief of police was able to say, okay, to release the person on his own recognizance was a traffic issue. And
Right.
the other matter where it is that we had to engage the magistrate had dealt with something that was not a traffic issue, but was a criminal issue on the books.
Correct.
Zita, I think you also have a problem. I think it arose a few months ago where there was some concern and disquiet about the amount of persons who have background as police officers. The police officers, they train as lawyers,
Right.
and then they are appointed as magistrates. And you feel that it was kind of the balance was not struck because maybe all the magistrates are never. Don't you want to comment on that?
Well, yes, I can comment on that. So we have had the experience that up until a few months ago, we had 3 magistrates who all had police background. And this wasn't police background, say, 20 years ago. This is current police background. When I say current police background, that in the case of one magistrate who's now retired a few months ago, he was, I think, assistant commissioner, deputy commissioner at the time when he retired, and then went straight to becoming a magistrate. And in the case of one sitting now, he left straight out of the police to become a magistrate. He was a senior police officer, I think he's an inspector, and became a magistrate. And as of August last year, we had a chief of police who left the police service, whether he's retired or resigned, say he retired, who became a senior magistrate within a couple of months. So basically, when you look at that, for us or for the Bar Association at the time, there is a disquiet that, one, in the first place, that someone can leave directly from being a chief of police and straight within a month sit there to listen to matters. And at the time, there were all 3 of the magistrates had strong police background. For us, and in the environment in which we live and work, I mean, human beings are human beings. No matter what you say, there's that how you feel, your prejudice, your biases will creep into how you conduct your matters. And even from the magistrate who retired, there were always allegations, which it is that you can see that there's pro-prosecution or pro-police type of decisions being made and how we treat them in the court. We do have strong police, call it training. That's not something that you have worked in a particular area and trained for decades, that you are automatically going to shred or shed from you when you sit in another job. It doesn't, that's not how the human mind works. It doesn't work like that at all. You don't immediately shut off from something. We'll hope that you will be able to draw yourself back when you recognize it. But there will be instances, and hopefully they decrease over time, when who you are trained as for decades may come through in the manner in which you treat people, and thinking that, because it's law and law, it's just a fine line between sitting here as a chief of police or as an inspector and then sitting there as a magistrate adjudicating over who is innocent or guilty, mindful, of course, you'll be able to apply the law to the evidence that comes before you, and whether or not the police officers who come before you, you believe their story. We know all the time that the manner in which police evidence works.
Well, let me ask, because I don't know if I gathered from you, from what you said, that someone came out from being a police officer practicing. I guess they'd have studied law while they were the
Oh yes, for sure. They're all legal background. They're all.
And then they'd be called to the bar. They'd be called to the bar. But they did not practice law for a period of 5 years, for example, before becoming a magistrate?
For instance, the officer, to my knowledge, former officer to my knowledge, who is now retired, was not a practicing attorney. Remember I said he went all the way up to being deputy commissioner or something, that a high ranking, and then retired. The officer, one of the officers who was appointed last year as a magistrate, he worked for maybe, I think it's less than 5 years in the office of the DPP. And then he was a police officer, trained, came out, worked in the office of the DPP, then went back to the police force and took up a position in the police force. The officer, the last magistrate who was the chief of police last year, who is now current magistrate. He was also police for many years, went away, trained in law, came back, worked in the office of the DPP for some years, might be around more than 5 years, then became chief of police, worked there for some years, and then became a magistrate.
But of course, the background does not automatically, it doesn't automatically follow that you'll be biased. But I guess
no.
Issues having a balance.
Yes.
From diverse areas, so that as to instill the confidence in the public that listen.
That's right. That's right.
I understand.
It is not that automatically we are saying that, oh yes, all of this. But for me as well, I think that, as I've said before, human beings are human beings, and our mind does not simply just separate from who it is we are in our training. And there may be instances where things will creep in. You just want to make sure there is a balance across the magistracy. The magistracy should not be staffed with people from one particular background. It's almost like simply saying all the magistrates have been prosecutors. All the judges are judges who have been prosecutors. None of them who sit on the bench have actually had private practice as defense attorney. You got to balance that out.
Okay. Francis, I know there's an issue in Grenada. You hear it on many of the calling programs about when in recent times, in particular with the opening of the assizes last week, about jury service. People complaining, people who are employees. But if some employers have been complaining, that they find it's unfair that, somebody goes for jury service and they have to pay them for the time when the person is off. The person not out doing their work, but they have to pay them. And apparently there are also complaints from people who have been called to do jury service that they receive either overt or, if not overt, some form of pressure, non-overt pressure from employers to kind of discourage them. I don't know if you could comment on that.
Well, that's a situation that has always been there. And I know senior colleague, Mr. Clauden, always lament about it, lament about the composition of the jury. I mean, I know there was a time, having the amount of jury to fully complement the pool. Now, on both sides, there are complaints on both sides. I don't think folks understand the importance of being a juror and the responsibility that comes with it. That's civic duty. And I don't think the employer also understands. Employers only want to see productivity, so you want your employees to be there and to carry out your work. Give their time because you're paying for time and skill. The court, though, treats it very seriously. When you're on that list, right, and you are commanded or summoned to appear before the court, and I'm saying that for folks out there who are jurors or potential jurors, when you are summoned to appear before the court, you have to appear before the court. If you don't appear, most likely than not, you will be fined by the court. Further, in terms of with the employers, what jurors have to do, or potential jurors, if you have a problem with your employer, report it to the court. Again, as I say, it's a civic duty. When you have trial by jury, which is only when you have criminal matters, by the way, not civil matters, but when you have trial by jury, the jurors are the arbiter of the facts. And the law says that you're supposed to be tried by a jury of your peers. It is so important that the jurors are the one that decide the fate of the accused, whether that accused is guilty or not the judge. That is how important the function of the jury are. You deciding the fate of that person, whether that person is guilty or innocent, based on the facts. So you, the judge of the facts, is a very important role that has to be treated seriously by both the person who is beckoned or summoned to be a juror and the employer. So I'm saying now, for the folks who having problem, I'm just reiterating with the employers, if you summon to be a juror, report it to the court. Now, you personally, if you're summoned to be a juror, you just can't opt out of it. It's something serious. It's also a learning experience. But people treat it as, I go in and sit down wholly in the court, and I can't do my job. That's how they see it. Now, wait until, you have they have a family member that is charged for an indictable offense and appear before the High Court, and it's a different story. Now, you have to put yourself there and do your civic duty. It's a duty. It's a duty to the state, and it's a very important function. Now, that being said, I saw an article. Let me see if I can just get it. I saw an article last week that someone sent for me where St. Kitts and Nevis National Assembly approved Joseph Ewart Layne trial, right?
Oh.
And I guess it is something, I don't know if the state is looking at it as well, but it is something that would eliminate a lot of hurdles and would ensure that justice is served swiftly. Because if you have Judge Layne trial, I mean, I hope there would be an option to the accused to say whether you want a jury or Judge Layne trial. Obviously, Judge Layne trial would be quicker. It wouldn't be for all the offenses. You have the judge who already legally trained, understands the law. So for folks who are unrepresented, you opt in for a jury trial. It is far quicker. You still have the same right to appeal. No, just to simplify it, every day in court, in the magistrate court, you have trial by the magistrate alone. You don't have no jury in the magistrate court. Some of the offenses are serious because now in Grenada you have grievous harm summary, you have sexual offenses summary, but they are serious as well. And you have the magistrate alone trying the matter. So likewise, if we have in Grenada that option to tell our accused that you can opt to trial by the judge alone or trial by the jury, I think that a lot of folks would opt for the trial by the judge alone, knowing that they have the same right of appeal as if it was a trial by jury. So I think that's something that we have to consider, since you have other OECS states adopting that approach.
But I should tell you that a few months ago, Mr. Bud Samuels, Jamaican attorney of over 40 something years experience. In fact, he was one of the attorneys, maybe the head of the team of lawyers in the John Campbell matter. And DJ Palmer was one of the persons, also known as Vibes Cartel. But he was on this program, and almost as an aside, he took the position that, look, listen, almost warning, do not go the way of judge alone trials. And he rooted it in the history of Jamaica. He said it is something he's fearful of, that the right to be tried by your peers is almost an ancient right that should not be taken away lightly. I understand in Jamaica you have the judge alone trial, but it's an option. So they put it in the accused, you can choose. Importantly, you can rescind your option at any time. That's what I understand in terms of Jamaica. I don't know if you want to comment on it again, or Zita, if you want to comment on that. Zita dropped off?
Yes, sorry. Yes, the internet. So what my understanding is, well, this was featured during COVID, the conversation about whether you want to have judge alone trials, given that the criminal division basically came to a halt, given that you have to have at the high court level a jury. And while the civil matters continued, and the whole idea was, here it is that matters are being delayed, the most, if you want to call it, some of the most important matters that had to do with people's liberty. Now, this has not been something that I know of that has been tabled here yet, but there has been a discussion regionally. And I would want to think that if it is going to happen in St. Vincent, it will take the model as well, that the accused person has a right to choose with education, because you should be able to sit down, and maybe that's something we have to do as well as part of the community engagement, to say, these are some of the things that happen. What are the pros of having this done? What are the cons of having this done? So the person has full understanding of the decision that he or she is making, why he or she may prefer to do a judge alone, or may say, you know what, I'm going to stick with the jury to listen to my matter. I remember in part of my training, one of the things that they've said a lot about magistrates and why the jury system is better is that magistrates after a while become hardened by what they see all of the time before them, the same kind of matters, and may not have or put in terms of the justice, apply their minds in a way that a jury may apply his or her mind. So if for those persons have an either way matter, it's a matter of explaining. If you stay with the magistrate alone hears, is mindful that a magistrate who have sat there for decades upon decades may be hardened to some types of crime, and that subjectivity may creep in. And then if you go to you want to your matter to be heard at the High Court, know that you may also have that jury to listen to your matter, and as you say, of your peers who may, if you want to put it in inverted commas, have fresh eyes to listen to this matter with the judge sitting there. So,
and you are speaking about England, right, Zita?
Yes, England. Sorry. Yes.
Where they have system of lay magistrates.
Yes.
So it's not just a professional single magistrate as we have in the Caribbean.
Right. That's right. Yes, you're very correct. Right. So I think the judge alone system should be. I think that there should be circumstances under which, so there is no delay, there's no stoppage of what should continue. And it may mean that it's the exception rather than the general way of business being done at the High Court. That would be my position.
How do you respond to the argument that in civil matters, where you have judge alone trials,
Right.
you still have a backlog?
You still have a backlog.
Can I chime in?
Yes.
The judge alone trial would not eliminate jury trial. They would coexist side by side. That's my understanding of how the system works. I think it's in Ghana as well. And I'm just reading from St. Kitts Nevis. That's how I understand it would work. So you have an election, right? So with civil matters, you don't have jury, you have only the judge. So you would still have a backlog. But then when you have in criminal matters that accused have that election and could say, you know what, I want to go judge alone trial, then it eliminates the jurors, and also the safety of the jurors too. You know, you have in some jurisdictions when jurors are actually scared to be the jury in a matter. So it eliminates that efficiency in terms of speed. You know, you get your trial in a timely manner, right? And as I say, the right of appeal, you do not lose that right to appeal. I mean, if the judge in summing up makes a mistake somewhere, whether it's a point of law or fact, and you find a ground to appeal, then you appeal. But so I think it's just that coexistence, that coexistence would ensure that matters are done speedily, thereby reducing backlogs.
Joseph.
Sorry, go ahead.
Sorry, if I may say though, the thing about backlogs will have to be an understanding of the different factors that influence that make that happen. Because I don't think that if it is that you're tried by a judge alone or judge and jury, then that is the situation around why there are delays. Only there's so many different factors that cause delay in the system. That may just be one. So even if it is that you have a judge alone trial in the civil jurisdiction, and still you have, but which is a situation, yes, you still have backlogs there. I remember when I just started, there was a second judge that was brought on into St. Vincent, the Grenadines, to try to get rid of the backlog. We only at one time had one criminal judge. Now we have two criminal judges, or two judges in the criminal division, trying to make sure that you don't have that backlog and get rid of that backlog. But sometimes you're sitting there, there's so many reasons why matters are delayed. And it has to do with the readiness of the matter. You have, when you arrest someone and charge them for an offense, the investigation at that point that you've arrested somebody ought to be that at this point in time, you have sufficient for a conviction. But normally what you have is that you have the matter there for the arrest and the police is still gathering evidence. You have further disclosure, more this, more that, whatever the case may be. And that can be one factor as into why you have delays and why matters don't carry on. Mm-hmm. The second reason why you may have some delays has to do with the number of adjournments. Some of them are based on the fact that the prosecution may say, we're not ready yet to proceed. And there are others where it is the defense attorney not ready yet to proceed. So there's a combination of reasons why you may have delays in the system. And I don't think that a lot rests on whether or not a matter is heard by a judge alone or whether it is heard by a jury.
Okay, Zita, just hold 1 minute. Before we move on, I just want to recognize and thank Gel Professional Solutions, Gem FM, broadcasting out of Canada, carrying this program tonight, and also to recognize Tao for the sponsorship.
Attention all workers. Your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Welcome back. I know society is changing, but I've read in that context the concern that over the last 50 years, maybe a bit more, there's been the constant erosion of the rights of accused persons within the criminal justice system. So, for example, at one time, a magistrate could only try summary matters. A magistrate could not give you a sentence of more than 2 years. If the charge was a summary charge, bail was automatic. You had a right to silence. You had a right to a jury trial. I say all this to say because I know some persons take the view that the trend towards removing jury trials. It starts now as an option at an election, but maybe someday may be the only option. It may be compulsory, but I know there is that concern. I'm not saying that, I'm not asking for us to go into that tonight, but I just want to situate that particular amendment in that context of that concern that there's been that erosion of the rights of accused people within the criminal justice system. I see here Sonia Nixon, who is a medical doctor. She's saying that potential jurors seek medical excuse from attending court. What is the court's position regarding illness and inability to participate as a juror? Francis.
Well, if you ill and you present a medical certificate from a medical practitioner, the court obviously would honor the medical certificate.
Right.
But that know at times there are jurors who abuse the process. I will go to medical practitioners and say they're unwell, and I mean I've known folks tell me that already.
Mm-hmm. So in other words,
the practitioners fake that they're unwell just because they don't want to be a juror.
So in other words, just say the medical doctor, as a community-minded person, should also say to people who may come to them in that regard, and may even express the reason why they want the sick leave, the medical exemption. Really explain to them, listen, that's a civic duty I should carry out.
Well, I can't see any medical practitioner going there because I mean you're compromising your profession and your integrity.
Okay.
I'm saying that you have folks who actually would go and pretend, fake that they're unwell just to get a certificate to present to the court. But if you telling the medical practitioner that, and the medical practitioner going ahead and issuing a certificate to you, then that person obviously compromising their profession and their integrity.
That's true. Okay.
Joseph, I just want to make a comment, a quick comment on what you said a while ago about eroding the rights. And I think it's a situation in terms of the ability for trials to be done wherein that the person who is pointing his or her finger and saying, I saw you do this or that, the anonymous witness, I think is one example. We have had a matter last year, wherein that the prosecution successfully had applied for its main witness and only witness to be anonymous.
Mm-hmm.
And so it really...
And not by that you mean that the person was given evidence, but the accused person did not know who is the person giving
That's
it.
right. The
You couldn't see
accused
their
person,
face.
you
Yeah.
can't see the person's face. You can hear the person's voice. You're not given any information on who this person is, so you can't do any background check to check on the person's credibility and giving that evidence to say a reason why Joseph Layne or Francis Paul will say what he is saying about me, Zita Barnwell. That's the first thing. Do you know this person? Yes. Do you know, to do that kind of background check? So it limits your cross-examination. You're supposed to be able to do cross-examination at large, but you can't because you're not even sure who is behind there saying what they're saying. And in that matter, too, not only was it that the person's identity was unknown, anonymous, it is that the prosecution was able to successfully apply to have so much of the material, if evidence, redacted. So to hide that person's identity.
And by redacting, you mean the cross line, so you
That's
can't
right.
know who is the person.
Yes.
So
To a lot of
you have a statement before you, name removed, address removed, and every detail that could allow you to make a check and identify the person is removed.
That's right.
Okay.
And further to that, in terms of hiding the person's identity, it was in terms of the evidence in relation to how their evidence is what they supposedly allegedly saw the night, where they were standing, where they saw all of this. That too was redacted. That too was crossed out. So you couldn't even say, well, we didn't know if the person lived in the neighborhood, if the person was at their house at the time. So what was also crossed out was anything in relation to, as the prosecution thinks, would identify Joseph Layne as the person. Now, you don't know, given the fact that the prosecutor had the liberty or the advantage to make that determination that if this house they know that this house that's involved, or where the person might have been standing, or whatever position. But one of the things that we were able to do though is even after looking at all of the evidence, it was to make an application for no case submission, which we were able to prevail on. But it was one of those experiences where there's a piece of legislation that allows that. And when you're talking about curtailing people's rights, they really should. And this was an allegation of murder. So it is a very serious crime. And the police and prosecution may do their jobs and really believe that based on what Joseph is saying, it has to be Zita. But at the same time, it's a good thing in a way that the manner in which displayed out that I believe that justice was done. There was a lot that was really, really not right in terms of the police investigation and how it was conducted. You had a situation where the photographs and details of the night that was done, all of that, the photographs that were taken, that they were lost. So you couldn't reimagine and what happened on that night by looking at the photographs where all of those things were gone.
But on the other hand, Zita and Francis, the reality is that in the modern world, even in the modern Caribbean, I'm not sure about Grenada as yet, maybe in St. Vincent, Trinidad, Jamaica, and some other states, jurisdictions not so far from here. People who come forward and give evidence in trials, right? Sometimes they do it at great risk.
That is true.
And the fact is that many times, like in Trinidad, the witnesses get killed. And one person, Cyrus Griffin, is asking here, what protection is there for jurors when they are dealing with criminal matters? And I guess that indicates that that concern. So I know it is that risk and that fear and that concern that is driving a lot of this legislation. But again, the whole issue is striking a balance. And to have a trial where you don't know who is accusing you, right? It's almost surreal. It doesn't really sound like a trap.
Yeah.
When you say you have to face your witnesses, and in particular, uh, when the allegations are serious. Francis, I don't know if you want to comment on that.
Well, you're talking about erosion of the rights of an accused. I find that's a huge one. Because as
Mhm.
Zita say, how you can have a witness that you don't know the identity of the witness, you can't see the witness. I mean, I know there in the developed world, there are instances where you may have an anonymous well, not anonymous, you may not be in the same room as a person, so the witness appears virtually, but you know who the witness is. But that witness appears virtually for the safety of the witness to protect that witness. But if you have someone as a witness and you don't know, how are you cross-examine that person, noting that person's demeanor? Because obviously you can't see the person. No, just to answer Cyrus Griffith, is there protection for jurors dealing with criminal matters? Not that I know of in Grenada. And hence the reason why, for me, I think that, having that hybrid system of, trial by judge only and jury trial is something that should work, because in terms of protection for jurors, if you have trial by judge only, it eliminates jurors being fearful because you don't have that juror trying that particular matter. But then again, in terms of trial by judge alone, it's only certain matters, right? It wouldn't be all matters. For instance, I was in a conference in Ghana in July, and I think Ghana is embracing that same trial by judge alone, and it's only for certain matters. Obviously, can be for all matters.
Mhm.
Joseph, if I may add, um, there are what you call oh my God, legislation for special measures. The anonymous witness is one aspect. That's probably really the most extreme, so to speak. But you also have what Francis mentioned there, and especially cases that deal with sex crime with with children. That's where I've seen the practice on the under 13, the statutory rape, where they give evidence from somewhere safe. You can see the child, but the child is not in the room. I think I really think that is a good move,
Yeah.
because have the child in the same room with the person he's accusing of sexually assaulted or raped me or raped her, raped him, takes away from them the trauma of having to see that you can see the person, but the person is nowhere close to you. The person in another room. I don't know that we have. I think one of the things in this also had the technology was, I believe it was said that even where the witness was anonymous, not only could you not see the person, but the person's voice was distorted. So that you can't see the person, you can't hear the person, you really don't know who this person is. That's the extreme. I think that may be useful for really heinous crimes. You see, for instance, we had that shootout the other day of where you had the 5 persons being shot and killed, and you have really good evidence and good people coming forward to say, I saw this person, but I'm afraid because he or she's a gang leader, whatever it is, whatever fair, legitimate fear he or she may have, but it's really good evidence. I even though as a defense attorney, I will fight for that not to happen. I also think that in terms of balancing, um, for certain types of really terrible, certain types of serious offenses, that it does have its place, so as to make sure that people feel protected if they see for sure, know for sure, and it's real credible stuff, that they should be allowed to give that evidence. It has its place.
Yeah. Francis, recently there was a decision from the High Court on a possessory type of matter that I know has caused a bit of disquiet. Uh, it's a decision of the court, but I don't know if you want to comment on the issue, whether there will be an appeal in the matter, or I know at least one prominent member of the Grenada Bar has written on it. And I don't know if you want to comment on it at all.
Well, I can see that it's causing quite a stir among the bar.
I don't know if you could just give a very briefly the nature of the decision. What exactly is the decision?
Right. So it's a judgment handed down by Madam Justice Agnes Acti. I think it's on I think it came sometime in August of this year. So basically, it's two parties application of Masha Berot and over Frank Roberts. So I'm just giving you my understanding of the judgment now and the background, what I think led up to it. So these two folks, it appears, had the title based on a statutory declaration or long possession, right? One would have been a deed of gift. I can't recall the genesis of the other one. But basically, what the judgment is saying is that the Possessory Title Act, right, was just let me look through and see if I find it. But basically, the purpose of the act is for persons who have been in adverse possession of land exceeding the limitation period of 12 years to apply to the court under that act to get an actual legal title to the land. Right? Now, these two folks, they actually have paper title. But I'm just assuming, because there are other attorneys who have several matters of a similar nature before the court right now that are coming up for hearing, some even during this week and later on. I'm wondering what would be the fate of those folks based on that's the judgment, right? So what the judge is saying, you already have paper title, and based on the authorities and also the purpose of the act, in essence, you can have paper title and applying under the Possessory Title Act, because adverse possession, you have to dispossess the person who has the actual paper title. Now, if you have paper title, then obviously you cannot dispossess yourself. And that is what I understand from reading the judgment.
Okay.
Now, there are several, as I said, there are attorneys who have several applications of a similar nature before the court, and folks who have gone to the bank, maybe for mortgage or otherwise, and the bank saying to you, I cannot take this property as security because your root of title of the genesis of it is a statutory declaration of long possession. So hence these folks now apply under the Possessory Title Act, right, to cure the title. That's my understanding. But what the judgment is saying that, no, you cannot cure the title like that because you already have paper title in your hand. So it's not adverse. Adverse to who? Who is the paper title owner? An adverse possession would only work when you dispossess the paper title owner. As the judgment say is nec clam, I think, nec pizzario, meaning that it must be overt, no force, so it's plain for everyone to see, undisturbed, that you've been there for 12 years or more, undisturbed, without any interference, without accounting to anyone, then the application will be successful.
Okay.
So it's a live.
Sorry, go ahead.
It's a live issue. I know I've spoken to one of the attorneys involved, and she indicated that she's preparing to appeal the matter. In terms of internally with the bar now, we have to meet as executive and also the general bar to discuss the implications for, as I said, the poor man out there who have that application now before the court, wondering, well, what would be the fate?
Okay. So if you don't have title, but you have been in possession because you threw out somebody who had title, then the court can help you.
Well, of course, that is the purpose of the Possessory Title Act. My understanding, right. The purpose of the act, and it says so, I think, in the preamble, the purpose of the act is to accommodate folks who have been on a plot of land for 12 years or more without accounting to anyone, to apply to the court for under the Possessory Title Act to get title. But from my understanding of the decision is that the two folks, because it's two applications so together, the two folks already have paper title.
But the title is defective.
Right.
In that it stems from long possession. So the root of title stems from long possession.
Mhm. Okay,
So
so
can,
that's sorry.
no, I just want to say because that decision in Grenada would have implication not only for Grenada, but for everybody in the Eastern Caribbean Supreme Court jurisdiction. We do have that same act.
Legislation.
Yes, and I do recall when that decision came out that it was a discussion as well in our WhatsApp bar chat, looking at it and how do you really cure that title? Because people would think automatically, an attorney might think that a way of curing this is to make an application for possessory title. But I do understand what the judge is saying. If the legislation is set up to saying 12 years undisturbed occupation and possession of this piece of land, and you're adversely possessing it, meaning that no one you have been doing, you don't know who the owner is, or you may have known the owner is, the person never told you to come off, and you are taking this away from that person having been there for 12 years. Now, I do have a paper title. I think a legal argument might be whether the paper title I have, as the word you just used there, is defective. If it's defective, then does it stand in law that I do have good title? And if I don't have good title, then seriously, I don't have any legal title to this land, right? I do have a beneficial interest in the land, but I don't have a legal title to the land. If the court, I think when the court made that decision, the court is recognizing that the paper title that these people have is good legal title, even if it is that the bank is saying, really and truly, I am not accepting this as good paper title, and I am not going to give any mortgage on this because something is wrong and defective with your root of title. Perhaps we just had a discussion with a colleague recently. We may have a similar matter in our office. Could we not apply to the court for a declaration, asking the court based on everything here, fixed date claim, asking us to declare us as the true legal owner of this land, and for the court and ask for direction that the registrar does make out or give a proper deed, then a deed title deed to this person.
Okay. So I guess
Wouldn't that then be an option if you can't? Because how then do you cure? You can't cure by going by possessory title, given the law locks you out. Then the person must have some redress through the court system to regularize that.
okay, so I guess we'll be hearing more about that in the future. Maybe I will even attempt to have a program on it specifically
Definitely.
dedicated to that. Yeah.
You would definitely hear more about it because based on the conversation I had with several of my colleagues, I just reiterating, there are several applications before the court and which have some serious financial implications for the applicants.
Mm-hmm. True.
Then the thing now, the issue now is going forward. I mean, how do you treat it in light of the judgment? I mean, and they are similar to the applicants in the judgment. So in light of that, going forward, right, if you go before the court, then it's automatically they would be treated in the same manner because you already have this decision. So what happens next? So that is a big issue now. What happens to these applications? You know, what happens to these folk who have expended so much money on the possessory title application? What happened to the mortgage, the proposed mortgage in the financial institution? So it has some serious implications for the applicant, financial and otherwise.
Zita, as we wind down, the vaccine case, I know that's a big case in St. Vincent. What's the latest on it?
The latest is that after being heard in April? Was it May last year? No, it was early this year. Yes, after being heard early this year, the Court of Appeal did return to St. Vincent last week, actually, and it was not listed for decision. It does not come back here. The court does not come back here, and I think around February. So hopefully it may be then. And it doesn't mean that we have to wait until February, just like it was heard. Was it St. Lucian? I think I can't remember which court was in session when the matter was heard. But it was certainly not St. Vincent's Court of Appeal hearing schedule when it was heard earlier this year. So I said that to say that if we need to have a decision, which we're looking for and really would like to have before this year ends, decision can be delivered in any court.
And the vaccine case, just for the viewers, is a case involving about 300 persons
That's right. Public
who lost
servants, teachers,
who lost their employment
yes.
when they decided they will not take the vaccine, the
That's
COVID-19
right.
vaccine, right?
Yes, the
And
COVID-19 vaccine.
they were told that they will be treated as having resigned their employment, abandoned their employment.
Right. So the state used an aspect of the public service regulations where generally it would say if you do not show up to work for 10 consecutive days, you're treated as having abandoned your job. Now, the public servants who refused to be vaccinated did not abandon their job. The majority of them, and all of them actually, showed up to work and were told not to come on the compound.
Right. So the issue,
yeah.
Right. So it's a big case because it affects a lot of people. 300
It does
individuals.
affect a lot of people. Yes, it does. Teachers, police officers, mainstream public servants. Yeah.
Okay, good. Well, we are about to end, and I want to thank both of you so much for coming.
Thank you for having me.
Participating so fulsomely. Yes. I don't know. Before we end, though, I want to once again thank GEM-FM, Gel Professional Solutions, and TAO for
Attention all workers. Your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Zita, closing comments?
Thank you. So I want to thank you very much for having me. Francis, thank you for being on this program with me. I want to also say in advance, congratulations for a packed and really interesting program you have for your Law Week. And to end, I want to say, for those who are listening, St. Vincent and Grenadines Bar Association will hold its Law Week 2024 under the theme Legal Pathways to Peace and Justice this entire week. We'll be visiting schools. We'll be having a pro bono all day on Friday. And we'll also be visiting at least one community engagement on Wednesday afternoon in Glen. And it is our way of giving back. It is the bar's first Law Week in a very long time. And I believe that we are off to a good start. And hopefully by next year, we are inspired by Grenada's wonderful program that's planned for this year. And we'll be able to do some of those things as well.
Francis?
All right, Mr. Layne, thank you very much for having me on the program. And Zita, it was a pleasure being here with you. I don't want to steal your spotlight and your bad spotlight, so I wouldn't make any comment about our Law Week. I just want to wish you success in your Law Week commencing from tomorrow, and that you have an excellent week, and that you continue to host your Law Week annually. And yes, when I roll out our Law Week, I'll give you feedback on the Pro Bono Day, which will be held on the Saturday.
Thank you.
Thank you. All the best.
Thank you.
So thank you, Francis. Thank you, Zita. Thank you to all those who followed. Thank you once again, Tao, JebFM, Gel Professional Solutions. Good night.
All right.
Bye.
Good night, everyone.
Night.
Take
Okay.
care. Bye.
Bye.